zoning on Singer Island, in our CRA district. It's very controversial right now, whether we should have high rise or mid rise or low rise. I think you had probably close to 200 people if you count the people that were
Did.
online
We did.
participate, and we had tremendous participation. And that was great to see everybody showing up and participating, caring, expressing their views. You're going to have many other times to do the same thing in the next couple of months. So please, stay online and watch what's going on. COSI, I'm sure, will inform you. My office will do its best to inform you of what's going on with the development projects. Uh, the I will be holding a town hall meeting on December 16th. So if you can put that in your calendars, it'll be at the event center at 6 p.m. at the marina. And we will be discussing the erosion. As you know, we brought plenty of sand onto the beach last year, thousands of tons of cubic yards of sand. It did its job. It took the initial shock of the storms and saved most people's properties and also help protect some of your seawalls from major maintenance issues. So it did its job. We have a 10-year agreement with the county. We're working with the county right now to work out some dates to bring some sand on. Hopefully they will. They're trying to use many excuses right now, like there's a lot of seawalls under construction, so there'll be a lot of trucks on the beach. You do know that they already started the Aquarius, the Sea Grape, and the Dunes will be doing their seawalls. The project is already in the works. Via Delfino and I believe the Sea Winds will be doing a portion of theirs, and that starts. I think I saw they already put the wood down for the entrance to the easement they have to the beach. So I guess that project is about, if it didn't already start, it's about to begin as well. I could tell you that 5,000, condominium 5,000 will be doing their seawall next year. I believe the beachfront will be doing the same. So basically, the north end of the island will be totally protected with seawalls by the end of next year, and that's a very important issue. We can't, of course, neglect the fact that water can come through the intracoastal, not just the ocean. And by the way, keep in mind, seawalls don't resolve all issues. They take the initial shock of storm surge in major storms up to about a 3 or a 4, but there are times where you'll hit a 5 at high tide, and the seawall will mitigate any damage, but it's not going to stop everything. You will still have some damage. But so far, we've been pretty lucky, and the seawalls have been doing their jobs. So that's important. So we'll keep you in touch when and if the county will be bringing their trucks on with more sand. As you know, last year, the county left really in the middle of the job. They had to, their sea sand person had to go up north to Virginia. The tide started changing against us. So the city took on uh, the project at that point when the county abandoned it. The city spent close to $600,000 and did our own sand project for the first time. So we now know how to do that. And we brought sand to Via Delfino and the Sea Winds. We expect to hopefully not have to do that again. Hopefully, we'll get the county to do what they're supposed to do. But the whole purpose uh, of the town hall meeting is going to be to have our coastal engineers that were hired by the county and the city that are looking into long-term solutions for the erosion issue, whether it be jetties, breakwaters, pumping, or doing nothing. They're going to come and tell us what they've come up with at this point with resolving a long-term resolution to beach erosion. So please be there on the 6th. We're also going to hear from our experts on the mooring fields. And I know that, Julie, you started this issue many, many years ago. We're finally at the point where the county and the state have approved two mooring fields for us. The people in Palm Beach didn't want us to have a mooring field near them, so we were rejected. Originally, we were accepted, and then we were rejected. So we're going to go ahead with the two mooring fields more than likely. We'll discuss that with the owners and residents, the owners of the boats that are out there now, and the residents on Singer Island and Lakeview Park, because they're also impacted. That'll be discussed at the same meeting. We hope to bring down the number of mooring uh, slips to about 30. Right now, I think it's at 51 at each site. We're going to try and bring it down and widen the channel. The whole purpose of doing a mooring field and having a lot of, uh, mooring sites is obviously to keep derelict boats out of there, make sure people aren't dumping sewage overboard. Everybody who's going to go into the mooring field is going to have to use our pumping facilities for their boats. And hopefully that'll resolve many of the issues. So please be there, speak up. Let's hear what your opinions are. That's basically it. You see the firehouse is under construction, but we'll talk more at the next meeting. I think that's enough for today. Let's hear from Ken.
Thank you, Glenn. Appreciate it. And
Thank
although Mayor Fires from Palm Beach Shores was unable to be with us, we do have the honor of having one of the council people from Palm Beach Shores, and that's Kathleen McGarren. And Kathleen would like to say a few words about what's happening over there.
Yes.
Good morning, everyone. There's many things happening in Palm Beach Shores. We have an election in March. Tracy Larcher is going to be our new mayor. He's unopposed in the election, so he will automatically be our new mayor. We have 4 candidates for the commission. Steve Smith is running again, and we have 3 other candidates. They just signed in on Friday, yesterday, so I don't know all their names. Sorry. The POA, the Property Owners Association, has a major food drive going on. You can drop off your materials in Town Hall. The town has a major drive to stop the proposed building on the corner of Lake and Blue Heron. The building is going to look like this. So we're very concerned. Notice the little homes in the back.
We can't see.
We can't see.
Kathleen.
You can't see.
Yeah, if you could hold up the elevation.
Can you see now?
It says you started screen sharing, but we only
I
see
don't see.
Kathleen McGarren has started screen. Oh,
There
there
you
we
go.
It is.
No, you can't see it?
And now we can. Yeah, we
You can
can.
see it now.
Well, this is very troubling to us. One, it's at the beginning of our town, but 2, it's going to seriously affect the activities at Phil Foster Park. So this is something we're very concerned about for many reasons, not just our town, but the environment and the effect it has on the swimming and scuba diving that's at Phil Foster Park, the environmental impact. So that's essentially what we're going to see. This is the proposal. It's on the website of Riviera Beach if you'd like to see the whole proposal. And
You should add, Kathleen, those are 2 28-story towers.
they're 220. I think they're even larger. And when I counted the floors on that scrap, it looked even larger to me, maybe 25. So
300 feet high.
300 feet. Yeah, I don't know what that translates to. I'm not a person that's in construction or engineering. Anyway, so we do have a major campaign on that. We're also working with people in Riviera Beach to try to stop this encroachment on our lives. We're willing to, go to the normal 8 stories. That's fine. We might even, go up to 10, but this building is an atrocity for our town. That's all I have to say. Thank you.
Thank you, Kathleen. Appreciate it. And now we're going to ask Barb Hanson, who was kind enough to set this meeting up for us, member of our board, to introduce our speaker. Barb?
Barb, you're muted. Still muted. Barb?
There we go.
There we go.
All right.
There we go. Sorry about that. Thanks, Julie. I'd like to introduce everyone to Ken Director, an attorney at Becker, or as some may still refer to as Becker and Poliakoff. Becker has multiple offices throughout Florida and the East Coast. Ken is the chair of their community association practice and has graciously agreed to speak with us today to help clarify, educate, and keep us informed on today's topics: board authority, navigating legal boundaries, and residents' rights. Thank you, Ken, for joining us today.
Thank you, Barb, and thank you for inviting me. It's been quite a while since I was able to spend a Saturday morning with this group. And I particularly appreciate being able to attend by Zoom because you saved me about 120 miles of driving and probably the temptation of the donuts that would have been in the lobby. So
Glad to help.
I'm glad to hear that the government authorities, from Glenn's comments, are doing something about beach erosion. No good deed goes unpunished, Glenn. You know, what you'll probably wind up with is some communities will put in a seawall, and then their neighbors who didn't put in a seawall complain about the increased rate of erosion on their properties because the water's diverted. So people can always find something to be agitated about. And as far as the construction is concerned, I strongly suggest that you recognize that the developers have much more resources than any of you do. And I won't say any more. I don't wish to impugn the integrity of anybody in the decision-making body at the town or the county, but I'm going to strongly suggest that you pool your resources and hire a government relations advocate to take your cause to the local government officials. Those are people who have better connections than you, with the possible exception of Glenn. If you really want to mount a professional defense to a professional campaign to build 2 28-story towers, hire a professional. That's all I'll say. Speaking of hiring a professional, in response to the subject for today, which is how to navigate, hire a competent community association lawyer. All of those words have significant meaning. Competent community association lawyer. Your son-in-law, the personal injury lawyer, is not the one who should be advising your community. Frankly, your son-in-law shouldn't be advising your community anyway. With a competent lawyer who knows the law, most of your questions can be addressed in a 15 or 20-minute phone call. So get competent advice. Y'all remember, at least those of you who are old as me, remember the commercial from the mechanic leaning on the hood of the car, holding a Fram oil filter. Do you remember what he said? You can pay me now.
Pay me later.
Yeah. So ask your questions before you jump into the deep end. And with that, I'm going to kick it back to, I think Barb was charged with sort of feeding the questions to me that had been submitted in advance. And the first several were all about fair housing issues and prescription pets.
Mm-hmm.
Now, I can go through them one by one, but in order to leave some time for questions at the end, let me deal with the fair housing issues in a fairly summary manner. Number one, make sure your documents take the position that you're trying to support, the position that you're trying to take. Saying we're a no pets building means nothing if your documents aren't crystal clear. A lot of documents say you can't have pets without the consent of the board. You should know there's a district court opinion from the 4th DCA that sits. That's what I get for knocking on my kitchen counter. Stevie, come here. Come here. There's a 4th DCA case that says that if your declaration says no pets without the consent of the board, guess what that means? That means pets are permitted. So know what your documents say. And if you need to amend them, amend them. You all realize there's no such thing anymore as a no pets building because people have the right to have animals if they qualify under the fair housing laws. There are 2 types, and I was asked about this. The difference between an emotional support animal and a service animal is that a service animal has certain certifications that he or she has been trained. But in terms of the rights of the resident who wants to have either an ESA or a service animal, they really are no different. There are people who have said in the past, I train service animals, so I have the right to bring them. The answer to that question is no. It's the handicapped resident that creates the entitlement to have an emotional support animal or a service animal. The unfortunate truth for all of you is that there's no template for how to deal with this. Every case has to be evaluated on its merits. And I realize there's a lot of skepticism about the validity of a lot of these requests. I can't remember the last time I was on a plane where there weren't a couple dogs on the plane wearing those little red vests. Anybody familiar with those?
Yeah.
Yeah, I
Frankly,
think you can buy them on Amazon.
You can't,
Yeah.
That's the point. That's the point I'm trying to make. Is but the dogs are sometimes better behaved than the kids. Um, the procedure is, once you know that you have a valid pet restriction that has been uniformly enforced, both of which are essential to any covenant enforcement, the handicapped resident has to submit something in writing from a treating medical professional. Now, it should be a professional who is licensed and experienced in the area that he or she is opining on. I don't believe you should have an OBGYN commenting on someone's mental incapacity. I've seen some fairly far-fetched letters. The second thing is the letter cannot say, Dorothy is my patient. She would benefit from having an ESA. That's not enough. The letter has to identify what the handicap is or the major life impairment and how the pet ameliorates the symptoms. Now, a lot of this can be bought online. So one of the benefits of consulting with competent counsel is competent counsel can spot a fake from a mile away. Because there are people who sell these letters for $75. It's become a cottage industry. So as much as I appreciate the aversion to spending money on lawyers, in this area, I believe you need to be very careful making decisions without consulting counsel, for the simple reason that if you approve emotional support or service animals where the proper documentation has not been submitted, guess what you've done? You've undermined the enforceability of your pet restriction for everybody, not just those with handicaps. On the other side of that coin, if you don't allow animals for which proper documentation has been submitted, you're going to get hammered. I've had clients hit with five-figure fines. I had one client forced to buy the complaining owner's unit for $150,000. You need to make smart, well-informed decisions when it comes to requests for prescription pets. Now, as far as the animals are concerned, no, you cannot regulate the breed. You cannot regulate the size. You cannot regulate the number of pets. If your documents say you can have one dog or one cat, but I need a service animal or an emotional support animal, that animal is by definition not a pet. So I can have that in addition to the dog that the documents allow, or the cat that the documents allow. Emotional support or service animals can go anywhere the owner can go, with two exceptions: into the pool or where food is prepared. Otherwise, they can go anywhere the owner can go. Now, here's the good news. If somebody has an emotional support animal and it relieves itself and the owner doesn't pick up after it, the animal is allowed to roam freely. The animal is left on the balcony and barks for hours on end. The animal lunges at or attacks people or other animals. You can have an emotional support animal or a service animal removed because the federal, state, and local law require you to make reasonable accommodations. And when an owner doesn't take care of the animal by picking up its waste, or the animal shows aggressive behavior or actually bites or harms other people or dogs on the premises, that is no longer a reasonable accommodation. I had one where the owner's animal was peeing in the elevator. We had the animal removed. So proceed carefully. It is always best to consult with your counsel. And if your counsel knows this area of the law, you should be able to get fairly quick, clear answers. And with that, Barb, is there anything in the questions on fair housing that I didn't address in that summary?
The first question that was asked is, we have many residents who purchased or leased in our community because.
Yes, I'll save you the trouble. I remember.
Okay.
The fair housing boards, this is going to come as a real shock to you. And yes, I'm being sarcastic. They err on the side of what? The association that doesn't want the animal, or the handicapped owner who wants the animal? Where are they going to tend to show favoritism?
Handicapped owner.
So when confronted with this particular question, their ruling typically is work it out, find a balance. If somebody is afraid of animals and the elevator stops on their floor and there's someone on there with their emotional support or service animal, they're going to say, wait for the next car.
Mhm.
If the person, I think what the question was, what if the person, so the people in the community have supporting mental health professional issues documented by a doctor that have disabilities, PTSD, anxiety, or cynophobia. I don't know if I'm pronouncing that correctly. How do they protect the rights of the disabled people who require an animal and the disabled people whose phobias or mental disabilities are caused by the animal? You've got two disabled people on two sides of the fence.
All of the decisions I've seen say the same thing. Find a balance.
Yeah.
Work it out.
Okay.
I guess the reality is, if you have that kind of an emotional disability where you can't be around animals, I think you know what I'm going to say. Don't buy in a multifamily building.
Yeah.
I hate to sound so dismissive, but I mean, let's face it. For a number of different reasons, there are people who simply shouldn't be living in a multifamily building.
I think that's why no pet buildings were created in the first place until the whole ESA.
I think you're right, and I don't know what is going to happen long term to the fair housing laws. I think at the outset they were a worthy idea because they protected the rights of handicapped people who needed a seeing eye dog or a dog for someone who was hearing impaired. I think we can all recognize that those are noble causes. But I don't think there is anybody on this call who isn't going to agree that the purpose of those laws has been expanded beyond any reasonable measure, and that they have been, for lack of a better word, perverted by a cottage industry and by people who simply want their animal.
Right. Exactly.
And that's unfortunate, because what it's done is it's created a level of cynicism and skepticism that is now directed at the people who really need their animals.
Yes, exactly.
I think at some point there's going to be a curtailment of the applicability of these fair housing issues. The current administration, whether you like them or not, has actually curtailed some of the HUD memos with regard to the scope of fair housing. The actual effect of that curtailment is yet to be seen, but I think at some point there will be a backlash to the I think the number of abusive cases where people have fraudulently requested an animal far outnumbers the number of legitimate claims.
Yeah.
And I hate to sound so cynical and so skeptical, but I just think that's where we're at. What did I miss, Barb? What else did I miss?
You covered number 2, which was the difference between the ESA and the service animal, and you covered number 3 about the breed and the size. This one is actually, I will say, this is from me. We have a building that has 60 emotional support animals in the building that have been approved. During the winter season, that will increase as guests bring theirs. And what I would like to know is what HUD document states that emotional support animals have the same rights as working service animals? Because in an old document that is no longer valid, called the FHEO 2013-01, it does specifically say that you can permit a person with a disability, or housing providers need to permit a person with a disability to live with and use an assistant animal. Assistant animal, for some people that don't know, is the all-encompassing service animal and emotional support in all areas of the premises where persons are normally allowed to go. However, that HUD document was retired and replaced on January 28th. And the new FHEO notice does not contain that language anymore. So my question is, what HUD document now supports the mindset that emotional support animals are allowed to go anywhere on the property their owners go? And then the second and third part of that is we have 2 restaurants on site. the emotional support animals are allowed to go in and on the patio. We do not have the required Food and Drug Administration permitting to allow the animals on the patio or in the restaurants. The Food and Drug Administration clearly prohibits live animals on the premises of all food establishments. So who holds precedence, HUD or the Food and Drug Administration? Because if you can imagine all 60 animals showing up at the restaurant, it's not going to be a very hygienic or could cause health concerns. And that rolls into the pool as well. The CDC has a model aquatic code, and they specifically require signage that says no animals on the pool deck unless it's a service animal who's been trained and as defined by the ADA. So if the pool, so again, who rules the pool in a the model aquatic even spells out condominiums not allowed at the pool. So who holds precedence, the CDC or HUD?
First of all, Barb, I'm going to suggest that that question has a lot of features that are unique to your property and that you consult with your counsel.
We
You do
have,
have-
and all he says is that they're allowed to go anywhere that the owners can go. And I said, there's no document that shows that. There's no HUD document that shows that.
What I will tell you is that there are over 30 years worth of decisions from fair housing boards and federal courts that do say that.
Yeah.
Yeah.
And I think you need to suggest to your counsel that he or she should document his or her advice by doing a spot of research. I mean, the truth is that under those decisions, Barb, an ESA can go wherever a service animal can go. That's just been the decisional law from the regulatory authorities for decades.
With the exception is that the Department of Business and Professional Regulations has said when we see them to send photos and to report, and they'll shut the restaurants down. And so has the Florida Department of Health said, if you see the dogs at the pool deck, report it, and they'll close the pool down.
Pick your poison.
Right.
Seriously, I'm not trying to be flippant, but pick your poison.
Yeah.
I mean,
Anyway.
allowing a service or emotional support animal that has proper documentation, which you are required to permit on the condominium property, in my opinion, should never be used as a basis to shut down facilities when you are simply complying with the law under the federal, state, and local fair housing laws.
Yeah. I'm looking at it as more of a hygiene and a safe. Again, if you had 60 dogs running around the pool and in the restaurants, that's not safe or hygienic for anybody. That causes
Well, you know, one of the opening comments you made about 60 dogs prompts me to want to ask your board, which I'm not going to do, which is how carefully did they scrutinize all those applications, or did they just roll over? No pun intended.
the attorney. The attorney approves the.
I don't know who your lawyer is, and I don't know what hurdles he made these people go through, but I'd be curious to know whether or not they were all properly and fully documented. Because I suspect that some of them were simply bought online, but I'm not here to impugn your counsel's work.
I would agree.
Next question.
Moving on. What documentation, I think you touched on that. What documentation can a board legally request?
Yes, you're entitled to a letter from a treating medical professional that states, that identifies what the handicap is, or at least what the permanent impairment is, and how the requested accommodation, in this case an animal, ameliorates the symptoms and allows that person to live independently.
Mm-hmm.
You know, I've seen some crazy ones. I've seen somewhere a 6-pound dog somehow enables me to take my daily walk.
Mm-hmm.
Because it provides me physical support.
This is the next question is more about, okay, the attorney for our No Pit building has approved 20 to 30 ESAs in the last 2 years. Some of the ESA owners have been heard in the common areas coaching others how and where to get fraudulent paperwork so they can also be approved for an ESA.
I saw this question and my answer is, what do you want me to do?
That's what the attorney says too, just let it slide. But it's
Well,
also
But you know what? There's nothing you can do about that. There are people who are going to undermine your rules. The best thing you can do, Barb, is make sure that your lawyer knows what he or she is doing with regard to these and can identify fraudulent documents, documents that were purchased online. Because just as I said, there was a body of law that says you have to respect the rights of owners with properly documented emotional support or service animals. There's also a body of law. There's even statutory authority for the fact that you do not have to accept applications that are supported by a medical professional who never met with the owner, who never treated the owner, and from whom the document was merely purchased online.
Mm-hmm.
But you have to be able to tell the difference between the two.
Mm-hmm.
Look, the upshot of all of these questions is consult with a lawyer who knows the fair housing laws.
Mhm.
I don't propose to or present myself as an industry expert on the fair housing laws. I know enough to be able to be dangerous and to be able to answer preliminary questions. But I have a lawyer in my firm who's an expert who actually conducts seminars for the fair housing people who sit on the fair housing boards. My goal as counsel for my clients is to help you make the right decision with these applications and keep you out of trouble.
I think that that's what an attorney's job generally is to keep people out of court. The unfortunate part,
but some people can't be helped.
The unfortunate part is I think that there are some people that are committing fraud, in my opinion, that are committing
Barb,
fraud that
I think a substantial percentage of these requests
are fraud.
Is it too early in the morning to say BS?
Yeah.
Never.
But the only way for you to distill the valid ones from the invalid ones is to work with someone who knows what he or she is doing. It's easy as a lawyer just to say, approve it. The law requires you allow emotional support animals. That's an easy response. The harder response is to look at it and identify whether the letter is sufficient. B, whether the letter is from somebody who is authorized to issue such a letter. And C, whether the letter was just purchased online by someone who's never actually met the handicapped person. There's a little bit, you need to be willing to dig a little deeper. Now, there's a point at which you have to stop digging. There's a point at which, the questions going back to the applicant have to stop because they've satisfied their legal obligation to provide documentation. But you have to be willing to dig a little bit instead of, again, no pun intended, just rolling over.
Right. I think the only other question on here that you haven't touched on, Ken, is regarding the animal itself doesn't, you touched on it earlier, but what should an association, whether it be property manager or board member, do in the event the animal itself does not have a right to be on the property? It's the disabled resident who has the right to have the animal to help them with their disability. So when the disabled person leaves for extended periods of time and leaves the dog on the property with the neighbor who is not disabled, what do people do? What would you suggest?
I would take the position, first of all, that doing so is a violation of your documents because the dog is not there with a disabled person. But I would also take the position that if this person submitted a letter saying, I cannot be without my animal, that maybe you didn't vet the request as thoroughly as you should have.
Mm-hmm. Yeah.
I mean, because most of them say, I'm going to take the animal with me to the pool deck. I'm going to take the animal with me through the lobby because I can't leave my unit without it.
Mm-hmm.
But I can leave town without it.
Mm-hmm.
Now,
Yeah.
if they left town to go to a hospital or a treatment center for some other ailment or for their handicap, that's different. Let's not lose our humanity over this. But for a person that says, I can't go anywhere without my animal, and then they leave town and leave the animal with a neighbor, that suggests to me that maybe you didn't vet that application well enough, and maybe you need to revisit it.
Okay. Thank you.
And how do you handle guests? If a guest comes in with an emotional support dog?
I would say to the owners that if you have a guest, particularly, for example, one of your family members coming down for Thanksgiving weekend, If they want to bring an emotional support animal, they are subject to the same requirements as a permanent resident would be, which means you better get us documentation in advance that justifies or supports their need for an emotional support animal or service animal on our property. Don't just show up.
I have a,
I
I have
realize,
a,
before you go, Julie, Glenn, I realize what I've just said is probably not the way it's going to work in the real world, because they're just going to show up. But if they do, then you send a violation letter to the owner. If you have fining authority or have fining set up, levy a fine. Maybe $100 a day for the amount of time the dog was there is worth it to your owner, but at least it's a deterrent. But you need to get the word out to your owners that if you have, and now would be a good time to send something out to your owners with Thanksgiving approaching to say, if you have family members coming and they intend to bring an animal that they claim as an emotional support or service animal, you need to get your documentation to us before they show up on site.
Thank you. Good.
and then I have a final question. Does anybody else have a final question before we move on to the new open carry law?
I got to tell you, I'm delighted to have questions for the first time in months that have nothing to do with reserves.
Let's move on to open carry, Barb.
I've got one final question, Julie. So just to be clear, because emotional support animals are allowed anywhere on the property, and because emotional support animals are not necessarily dogs, if I have a
Barb, you said anywhere on the property. That's not accurate.
Oh, except the two places, the pool and the, yes.
Thank you.
Yes. So if I have a Burmese python, I can bring it with me to the restaurant?
Is it an emotional support python?
Yep. If I have paperwork for it?
You know what? I think we're getting a little far afield, Barb.
Yeah.
I'm just saying, it doesn't have to be a dog. Somebody could have a potbelly pig or a rat or anything.
Barb, I had a lady submit a letter saying, I need to have my son here because he's handicapped. He's mentally handicapped, and that's what makes him a rapist.
Oh, Jesus. Okay.
So this can get a little silly.
But you can see how I'm playing devil's advocate. But
I know you are, but so am I. Does anybody on this call think that a Burmese python could be an emotional support animal?
No.
But a potbelly pig, they brought him on a plane. So
yeah.
What the airlines have to do as a public carrier may be different from what you have to do as a private residential property.
Mm-hmm.
Let's move. We have limited time, so let's
okay
to open carry.
So for the new open carry law, at the October meeting, the law enforcement reps.
Yeah, I will save you the trouble of teeing that one up.
Okay.
Florida has had a prohibition against open carry in its statutes. An appellate court said that prohibition is unconstitutional based upon the Second Amendment. The Attorney General chimed in and said, yes, open carry prohibition is no longer the law of the land. How many of you feel comfortable with people walking around with gun belts on with a gun hanging off, or coming to board meetings with an open carry weapon?
Not me.
Oh, thank you.
So both the court opinion and the Attorney General opinion left open the opportunity, or at least the suggestion, that a strictly private residential community could still regulate open carry on their private residential property. Let that sink in. Your attorney should be able to prepare for you a resolution. God, I miss the days when I used to say I can prepare this for you, but since I'm not counsel to many of you anymore, but your attorney should be able to prepare for you a resolution the board can adopt to prohibit open carry on the condominium, cooperative, or HOA property. Now, the problem is once you go to the DBPR to enforce, or you go to a court to enforce, you've now created a potential constitutional problem for yourself, because you've now invoked a state actor to help you enforce. And the reason this law was struck down, and the reason the constitutional amendments are applicable, is because they apply to actions taken by the state. Once you take one of your restrictions and you go to court to enforce it, you've brought the state in to enforce it. When you go to the DBPR, which is a state agency, you brought the state in to enforce it. And I can't tell you for certain how those state agencies, whether it's the courts or the DBPR, are going to react when they are confronted with a Second Amendment argument saying you can't enforce this because you're the state. And I have a constitutional right to have my weapon, and the state can't tell me that I don't have that right. I don't know how that's going to work out. So adopting the rule is the first half of the equation. And I'm not suggesting that you shouldn't do it, because I don't think any of you want people showing up at your board meetings, carrying an AR-15 on their shoulder. That might affect how the board acts. I know it would affect how I'd act. I'd say, I'm sending associates to your meeting from now on. We can make light of it, but do any of you really believe that what we've seen happening with gun violence in our country is never going to make it into your board meetings? Because if you believe that, you're living in fantasy land.
Yeah.
How many of you have gone the last couple of years without anyone throwing a tirade at a board meeting? And how big a step is it? It's not a quantum leap to go from there to somebody throwing a tirade with a weapon in their hand.
Yeah.
And could you imagine anything more horrendous, really? Other than school shootings when it's little kids, having that come into your community is talk about the ultimate pox on your property values and your quality of life. Not to mention, who the hell would want to serve on the board?
It did happen in Toronto about a year or two ago. There was a shooting in the boardroom.
I represent a community down on Palm Beach where a disgruntled former security guard, 76-year-old guy, walked in because he was fired because he was sleeping at his desk and shot the manager in the head.
Wow.
God.
We live in a highly toxified environment, unfortunately.
Mhm.
Regardless of your politics, you have to acknowledge the fact that we live in an environment right now, whether it's the internet or whatever it is, that it makes people feel much more free to express their venom and their hatred. And it's an unfortunate reality. Maybe our kids will live in a more peaceful environment than we're enduring right now. But the ultimate step in terms of the growth of that violence is having a proliferation of guns. I believe in the Second Amendment. I believe you got the right to own a gun for your protection. I have one in my home by my nightstand because I'm just a little old Jewish guy living by himself with his dog. You laugh, but it's the truth. If 3 men came into my house, I got 20 rounds in the clip. But carrying that weapon around to meetings, brandishing it as a threat to people who disagree with me, whether in the grocery aisle or at the board meeting, we can't have that. So notwithstanding the constitutional issues, I would encourage all of you to take to your boards the idea that you should adopt a resolution against open carry on the common areas and common elements and association property of your community.
And then Ken, is that something that could be a change of a rule and reg and approved by the board, or does that have to work its way into the bylaws and approved by the owners?
Barb, your question assumes that the board has unfettered rulemaking authority. Not all documents have that.
Okay.
So you need to check to make sure your bylaws, your articles, your declaration grants the board rulemaking authority. That is not automatic.
Okay.
The association has rulemaking authority, but not necessarily by unilateral action by the board. But in answer to your question directly, Barb, if the board has rulemaking authority in your documents, then yes, I believe this can be adopted as a rule.
Okay, thank you. Does anybody else have any questions on this topic?
To borrow from the English mantra, God save the board.
Then we had
ahead,
a lot
please.
of, okay,
Go ahead.
then just general
I'm sorry,
questions.
hey,
Frank,
Barb, I'm sorry
Yes.
to interrupt. I do have one question if you're going
Okay.
to move on to another subject.
sure.
Ken, my question is, if in fact the board takes no action on this, for whatever reason, maybe they just totally ignore it, because I'm aware that I'm aware, particularly in our case, that there have been requests that have been submitted to the board.
You're going to ask me, is there liability?
Exactly.
Let's start by stating the obvious. Who has the biggest liability policy?
The
The association does.
association.
Yeah.
Anybody can sue
Right,
anybody for
D&O,
anything.
right?
So you're going to get sued.
Yep.
But the actual legal liability depends upon a number of factors which you haven't addressed. Are you aware that this person was dangerous? Has
Yeah.
this person made threats to come in and shoot everybody? There is a point at which the board is obligated to act. One of the bases for individual liability for board members is a failure to discharge your duty to protect the person and property of all of the residents. So if you are aware of a threat and you do nothing about it and it escalates, as threats tend to do, you're going to face liability.
Yeah. Okay.
A random act, somebody just coming in off the street, shooting the place up, I don't see how that's foreseeable. Doesn't mean you're not going to get sued, because they're going to want to get a piece of your liability policy, and most of you probably have a large umbrella policy as well.
Right.
At least I hope you do. But I don't think the fact that something horrendous happens on your property automatically equates with legal liability for the board. But you've got to get your head out of the sand if there are things going on which warrant a response from the board.
Okay. All
You
right.
can't ignore it. I mean, if you have people coming in from the beach who don't live there, going through the property, and you do nothing about it to install some measure of security, you know that those people coming in from the beach are going to become more problematic, because not so desirable people are going to start to do the same thing.
Yeah.
If there is a security issue, you must address it.
Thanks, Ken.
Right. Any other questions?
Barb-
Frank?
Bob, the question is the board's ability to limit unruly guests of unit owners, especially with police intervention, not just letting them back into the unit.
Do you
What-
have a gate? Do you have a front gate, Frank?
Yes, we do. This is a unit owner on 2 different occasions invited it. One turned into a domestic situation where the young lady refused to leave and it got a little bit hostile. And then the second situation is a guest of another unit owner who, let's just say he was found naked in our lobby and on 2 different occasions.
Is that something you indulge regularly at your building?
No, this is not that type of community. We're not in Southern California, Ken. We are in Southern Florida.
There's a nudist condo on the west coast of Florida.
Oh, great. Maybe they're moving in.
Gary Polyakov had a lot to say about attending their annual meeting. Listen, all kidding aside, by law, who has the right to be on your property and be in the unit? The owner.
Yes.
Tenants have the right to the extent it is granted to them in a lease by the owner. Guests have the right to the extent they are invited by the owner. If you have anyone other than an owner violating your documents, one of your remedies is to remove them from and bar them from the property.
Okay.
There's actually authority for that with a former manager who people kept inviting to come back to the property, and he was disruptive on the property, and the division held that it was within the board's authority to bar him from the property.
Okay. Perfect. Thank you.
But
Uh-oh.
document the violations.
Yes, we have. Yes.
When people act like criminals, call the police. When people violate the documents in a less than criminal manner, document the violations with demand letters. Because barring someone from the property where you have no record of any violations,
Right.
you can see the difference.
Yes.
Mhm.
Okay. All right.
Thank
Frank got his question out of the way, so let's move into the general questions.
Yeah, does a board have a right to increase an assessment for a major renovation far beyond the community's original vote? If so, what are the parameters? If not, what action can the community take to act against the board's action?
Does the board have unilateral special assessment authority under the documents? Don't answer that, but that's not axiomatic. Some documents do not allow the board to levy special assessments at all. Some have a percentage cap or a dollar cap on the board's special assessment authority. So the first question, Barb, is does the board have unilateral special assessment authority, or would this assessment go beyond its permitted limit? Let's assume the board has unilateral unlimited special assessment authority. If you submit a proposed project that is an alteration that requires membership approval, and you tell the members the answer to the only question that really matters to them, which is what is it going to cost, and that turns out to be false, my answer to your question is the board may still have the power to levy the assessment, but I wouldn't.
Okay.
There's a benefit to transparency. There's a benefit to not tweaking your nose at the members. Could you do so legally? Probably. Will you see, torches and pitchforks coming after you? Probably. I understand that sometimes projects involve unexpected issues. I had a client down on Palm Beach where they were going to redo the driveway, and it turned out that the town ordered them to replace all their underground cast iron pipes at a cost of an additional $4 million.
Wow.
Now, did they have to go back to the owners for that? I would say no. Why? Because the driveway was an upgrade, which required a membership vote. Why would you spend a few $1 million to put in a new paver driveway and then have to tear it up to spend $4 million to replace the underground pipes? Now, I will tell you, even with something that was mandatory like this, the members were in an uproar. You told us this was going to cost $2 million. Now it's going to cost $6 million. But there's a difference between additional cost overruns that are based upon unknown maintenance needs, work that has to be done, and the fact that the upgrade project was underestimated. So use your heads. Use common sense and err on the side of being transparent. Next.
This one is about violations. So the board refuses to fine some residents for smoking in non-smoking areas on the property.
Yeah, I saw that one, Barb. You know what? Do you have a valid no smoking prohibition? That's the first question I would ask that person. Was it enacted as a proper rule? Was it enacted with board authority at a properly noticed meeting? Or was it properly adopted as an amendment to the documents? Yeah, I'm aware, after 40 plus years of doing this, that a lot of people adopt rules because they don't want to go through the trouble of having the members vote to approve an amendment. Some rules are not valid because they conflict with rights that are inferable from the declaration. It is always safest to do a document amendment, especially on something as important as smoking. But assuming that you have a validly enacted restriction and the board is not enforcing it, get a new board. Seriously, if you are unwilling to serve on the board, then don't criticize the people who are willing to take the heat. Listen, I also understand, having been through this hundreds of times, that the level of epinephrine that is flowing through your veins, the level of amped up that you are when you're drafting rules, is here. Mm-hmm. But the level of chutzpah that you have when it comes time to enforce them is here. It's just a human dynamic. You want to regulate everything. But when it comes time to enforce, you say to yourself, well, does it really matter? Only adopt the rules that you are prepared, if I can invoke Sonny Corleone for a moment, only adopt the rules on which you are prepared to go to the mattresses. If you're not, don't adopt it. If you're not prepared to enforce the no smoking restriction, then remove it from your rules. If it was amended into your declaration, then you damn well better enforce it.
So I think some of the things that you keep talking about is amending some of the government governing documents. Ours here, the community Julie and I are in, haven't been done since 1977. So, how often do you recommend people have their governing documents updated?
Well, you don't have to update them. It would sound incredibly self-serving for me to say you should update, or for any lawyer to say you should update them every couple of years. I don't subscribe to that. I think I think if you have documents that are 50 plus years old and still are replete with obsolete references to the builder, are not consistent with today's statute, are not consistent with the values of the post-developer ownership, for a developer who's probably been dead for 50 years. There are, this is a lengthier topic, but let me get into it for a moment because this is an important topic. There are 3 reasons to update your documents. Number 1, to eliminate the obsolete references to the developer. That's not a sufficient reason in and of itself. The second reason is to bring them up to date with the law. That's an important reason. The third reason is to make sure the policy provisions are consistent with the values of your owners. And the policy provisions fall into about 6 categories. Number 1, when a membership vote is required, what should it be? Should it be a percentage of everyone or a percentage of those who vote? Bear in mind that if it's a percentage of everyone, those who don't vote have to be counted as a no vote.
Mhm.
So for those of you who are reluctant to undertake membership votes to amend your documents because people just won't vote, do it once. Do it once, bring the percentages down to a percentage of those who vote or to something that is more reachable for you. So that way you can get on with the more important amendments because decisions should be made by the people who are willing to show up. Especially when showing up means you can come to the meeting in person, you can send in a proxy, and for those of you that have implemented online voting, you can just log in and vote online. There's no excuse for an owner not to vote, and frankly, there's no excuse to allow people who won't participate to effectively exercise a veto on everything else. So that's number 1. What should the voting threshold be? Number 2, are the maintenance and repair obligations clearly divided between the association and the owner? If this is the pipe that runs from your sink to a vertical riser, a main line, and this is your sink and this pipe serves only your unit, who should be responsible for this pipe if this is the wall that divides your unit from the common elements? And don't even try to answer it because you don't know. Unless you've amended your documents to say that a pipe that serves one unit is the responsibility of that owner up to the point that it connects to a common line, then you have clarity. If it just says the pipes inside the unit are the owner's responsibility and the pipes outside the unit are the association's responsibility, what do you do with this pipe that is located in part inside the unit and in part outside? And you'll say, well, wherever the leak is. To which I say, how do you know where it's leaking until you pull it out? So clarity in terms of the maintenance and repair obligations as between the association and the owner will save you a lot of money on lawyers. Because if you have a plumbing leak, if I'm your counsel, I would prefer that you call a plumber than a lawyer. Because I ain't coming out to fix the pipe. The next area of policy is alterations. And alterations fall into 2 categories. Those done by the association and those done by the owners. Most community owners they're skeptical about amendments that give the board any authority to approve alterations without a unit owner vote. And I emphasize that alterations does not include necessary maintenance, repair, or replacement of existing components. I'm talking about if you want to put in a putting green, or you want to put in a porte cochere, or you want to redecorate the lobby, or redecorate the hallways, or paint the building a different color. It is my opinion that the board should have some minimal spending authority for alterations. For example, if you have a manager who sits in an office and the office is painted white and you decide you'd like to paint it, light blue, believe it or not, that's an alteration that requires a membership vote. I think, the $40 you're going to spend for paint and for one of your staff members to paint the walls probably doesn't justify the expense of a membership vote. So you should address alterations in a way that makes sense so that the board can't go out on a lark of its own to make major changes to the common elements, but can do minor things like painting the walls in the office. The other more important issue is owner alterations, and you should amend your documents, especially if you have those late 60s, early 70s documents that don't address what types of alterations inside the unit trigger an obligation to get approval from the board. That should be clear. And what documentation is required to be submitted so the board can make an informed decision. This is a very important provision, particularly in older buildings where new people coming in are going to want to make major renovations. I mean, let's face it, your buyers are not people in their 80s or 90s. Your buyers are people in their 40s, 50s, or 60s who are going to come in. They're going to want a state-of-the-art gym. They're going to want to renovate the unit. There's going to be a push and pull between those buyers and the existing, forgive me, old timers who are in their 80s or 90s who don't want to spend any more money. And you're going to have to navigate that. But you have to be competitive in the marketplace. So we've talked about membership votes. We've talked about maintenance allocation. We've talked about alterations. The next area is, of course, screening, sales, and leases. You should have some right to say no. You should have a right to say no to a proposed tenant who has lived there before and was a constant problem. The real challenge is with potential purchasers, whether they are buying or inheriting, even from a deceased parent. How many of you would feel comfortable with a convicted pedophile buying a unit in your building? What if I told you you can't say no unless you're prepared to provide a substitute purchaser who's going to buy on the same terms? There's nothing in the law that says you can turn that person down. He or she has served his or her time. They have every right to buy there. There's no law that says, that, unless you're within 1,000 yards, I guess, of a school. So you should look at your screening provisions and make sure they have some teeth. The last areas, I'm going to skip the area about eligibility for the board or board terms. I assume a lot of you have already gone to staggered terms, multi-year staggered terms, which I think is a good thing. Eligibility for the board, you may want to consider whether or not it should be restricted only to people who are title holders, because some of you may have spouses who would make better board members than you. Just ask them, they'll tell you. So the last policy area is the use restrictions, which was the subject of a lot of the discussion we've already had. You're all beachfront properties. Guest occupancy is an important issue, especially in the era of Airbnb. You should have clear restrictions in your declaration, not in your rules, in your declaration regarding guests, whether they are there with the owner in residency, which would be less restrictive because the owner's there to account for his guests, or they're not there with the owner, in which case you want to be restrictive. And for guest occupancy in the absence of the owner, you also want to distinguish between the owner's family, because nobody's going to want restrictions on the rights of their children or grandchildren to come stay in their unit. But for your Army buddies, or for the person that you claim is, a high school friend, but who's actually a short-term renter there on an Airbnb, those you might want to restrict. We've talked about pets till I'm blue in the face, so I don't need to get back into that. But I will tell you this, rather than trying to list the animals you don't want, from a drafting perspective, tell your counsel that these are the only pets we want to permit. Don't try to list everything that is prohibited. Say these are the only pets that are, or animals that are permitted, everything else is forbidden. That's a lot easier to draft. A lot of older communities impose restrictions on how units could be titled, saying it can't be owned by a corporation. I have to tell you, I don't care. How the unit is titled has no impact on day-to-day operations. How the unit is occupied is what affects your day-to-day operations. But you should allow your owners to engage in estate or financial planning using whatever vehicles they need to title their units, as long as you draft into your documents the appropriate occupancy restrictions. So, for example, if a unit is owned by an LLC, you can say they have to designate a primary occupant, and they can't change that primary occupant more than once a year. Pardon me 1 second. My dog is asking for permission to go outside.
Ken, I'll take this brief pause in the action here to say thank you. And I know that we're a little bit over time, so
Yeah, and I'm wrapping up.
when you get, okay, good.
And I'm wrapping up. The other types of restrictions, especially for those of you that were created in the 60s or 70s, is vehicles. Back then, there was no such thing as an SUV. And pickup trucks were considered an eyesore. That's not the world we live in anymore. You can certainly restrict the size of vehicles so people can have visibility. But to say no pickup trucks or no trucks and only passenger automobiles, that's just not the world we live in anymore. And then there are, the last one I'm going to address is smoking. There are a lot of communities that are amending their declaration to prohibit smoking anywhere in the building or on the balconies or outside the building. Because you have older buildings that have that plenum space above the ceiling. And if I smoke in my unit, especially if I'm smoking a cigar or a pipe, the smoke gets up there and it goes down the vents into your unit next door. That's a very popular amendment these days, which is to begin to prohibit smoking. And if you're going to prohibit smoking, my advice is prohibit smoking anywhere in the building or on the balconies and designate a spot away from the building on the common areas where smoking is permitted. And with that, I'll wrap it up.
Thank you. Thank you
Thank
so
you.
much, Ken. Thank
Great
you,
job.
Barbara, for putting this together. Thank you for collating the questions for us. Ken, you've given us so many great ideas and things to think about, and we really appreciate your presence here today. So
It's
Thank you.
my pleasure.
thank you.
Good
Have a good
program.
weekend, everybody.
Wait,
You
just
too.
Great
thank you.
weekend. Thank
Just
you.
Before
Thank
you
you.
go, everybody, I want to remind you that our next meeting on the topic of the Legislative Watch is going to be in December on the 13th. We'll have County Commissioner Bobby Powell with us. We'll have State Representative Tay Edmonds, and we'll have former State Representative Mike Caruso, who's now the County Controller. So please be sure to sign up for that. Look at our COSI.org webpage to sign up for future meetings. And if there is nothing else from any of my board members, any words of wisdom? So thank you all for being here. We really appreciate your presence. Have a great rest of your weekend. Bye-bye.
Thank you.
Goodbye,
Thank you.
everybody. Thank you.
Bye.
Hi, everybody.
Thank you.
Thank you, everybody.
Thank you so much.